and welcome to Pratham Test Prep. I'm Ashish Bhargav and welcome to another episode of Deep Dive. And today's article is very important that we discuss about is UAPA, which means Unlawful Activities Prevention Act. As we know that in the present scenario that most of the act and amendments used to ask in your CUT exam, in CLAT exam, every law entrance exam is as we know there are many questions that is based on as we know the amendments, constitutional provision and amendments act. So to keep in these things in mind that you need to discuss, you need to think about what exactly is UAPA. As we know that Unlawful Activity Prevention Act, when it was enacted in 1967 and later on amended in 2019. So what kind of things, what kind of constitutional provision has been amended and what exactly is Unlawful Activities Prevention Act? As we know that in CLAT and AILET exam and law exam, there are most of the questions and passages that is based on as we know the act questions. In this year, that AFSPA, which means Armed Forces Special Protection Act, has been asked in this year. There might be a probability that they will ask the question that is based on many acts which is in the news. And recently, PFI has been banned. Popular Front of India, which is a Muslim organization, and as banned according to the Unlawful Activities Prevention Act. As we know that Unlawful Activity Prevention Act, and why this is very important, because PFI has been banned with the help of UAPA as per the guidelines of Ministry of Home Affairs, and PFI has banned as per the sovereignty, integrity of the nation. Unlawful Activities Prevention Act 2019, which deals with Parliament enacted UAPA Act 1967. And one more thing we need to keep in mind, what are the provision? National Integrated Councils. And as we know, National Integrated Council headed by the Prime Minister on that time enacted 1967 UAPA. What are the provisions in UAPA? Declaration of an association as unlawful. Declaration of any association that is unlawful if the person and somewhere in an organization which is against the sovereignty of our nation, that can be legally declared as unlawful. Second one that we can say, penalty for being an unlawful association, which means if you are being associated with such organization that is counted, that is known to be a unlawful, and which is you are detained under Unlawful Activity Prevention Act. And the third thing that you need to keep in mind, penalty for dealing with funds of an unlawful association, which means that any XYZ organization is running and you are funding to that organization, that means you are under the UAPA. As we know that is very good for the curve of Terrorism Act in our country. But if you go to the very depth, you got to know there are many pros and cons, there are many advantages and disadvantages. There are many who is favoring this, there are many who are against this. Who is favoring? One who wants that country should be terror free. And why one who is against this? Because the term Unlawful Activity Prevention Act, someone who is detained, that we can say that the person cannot hire and lawyer, and we can say 180 days in judicial custody without any FIR. So UAPA basically deals with unlawful activities and terrorist activities. Now we're further moving. If you are new in this channel, please subscribe, comment and share to your friends, which is very beneficial for everyone. And one more thing is that if you have anything, that please let us know in the comment section. About current affairs, the best way to know about current affairs is to study newspaper and magazine. One should study magazines on a daily basis to update it by current affairs. And here is the quote: Failure is one, the opportunity to begin again, the time more intelligently, that is Henry Ford. And as we know, there are many detentive law in our country, that many laws which is curved the terrorist law in our country. Preventive Detention Act, which is in force in 1950 to 1969. Armed Force Special Power Act, which is asked in the CLAT 2022, which is 1950 till now. 90 is northeastern part of the country, and Jammu and Kashmir as well. 1967 Unlawful Activities Prevention Act, UAPA, which we will discuss in the today class. 1971 to 1977 Maintenance of Internal Security Act, and 1980s to now National Security NSA, which we will force in the time of the last year Independence Day to detain anyone who is supposed to be like involved in any terror activities. And 1985 Terrorist and Disruptive Activities Prevention Act from 1985 to 1995. So where is the article that we have extracted from the Indian Express? As we know, the date is 10th October 2022 and today newspaper, and here is the article published in September 29, 2022. Appealing of PFI ban how UAPA tribunal works. UAPA provides a tribunal under a high court judge to be constituted by government for its bans to have long-term legal sanctity. Here we need to think it out. We will discuss how UAPA will work. While we go further, moving PUCL report alleged abuse of Unlawful Activities Prevention Act, the same article as we can see that is published on October 2nd, 2022. 8 days before, and this article is published in The Hindu Delhi edition. And if you go to the third one, that article published in September 29, what ban on Popular Front of India means. Because as we know that PFI has been declared as unlawful association, which is UAPA defines as an association that has for its object any activity that is punishable under section 153A and 153B of Indian Penal Code, which is promoting enmity between groups and making imputation assertions prejudicial to national integration. So this article basically is talking about mainly the UAPA. So in depth, because in deep dive we discussed about each and everything which is very in detailed manner, so that the students does not escape any questions which we will probably to ask in your examination. So as we know, the repeal UAPA, this article, the statute has no place in democracy. Sometimes earlier there's an article which we discuss about that UAPA is kind of draconian. Draconian, which means that we can say the law is something talking about arbitrary manner. Because UAPA become a terror law after amendments were introduced in 2004, but successive amendments between 2008 after the Mumbai terror attacks and 2019 significantly expanded the scope of this act. Ironically, UAPA has come to resemble two provisions and hugely controversial terror law. One was the Terrorist and Disruptive Activities Prevention Act, TADA, passed against the backdrop of turmoil in Punjab and the war 1995 after the vortex of criticism of human rights activists for giving the security agencies and curtail balance of arrest and torture citizens. The second was infamous Prevention of Terrorism Act, POTA. As we know, Prevention of Terrorism Act, POTA, in 2004, which the famous actor, as we know that Tada, Sanjay Dutt, was arrested in Tada Act. So as we know that the infamous Prevention of Terrorism Act, POTA, which allowed amongst other things confession obtained by the police to be submitted in evidence. This law was allowed to lapse in 2014 to stem rising criticism against its misuse by some states. But the elevation of the UAPA to the status of the country's chief terror law has enabled governments to extend, with creative variation, the spirit of TADA and POTA to stifle dissent. This became easier after the 2019 amendments that allowed the government to name individuals as terrorists. Previously, only organization could be given this tag. In a UAPA, that we can say any individual can be arrested, any individual can be defined as a terrorist. So underlining this motive in this fact that according to the Home Ministry data, there has been a 72% increase in the number of arrests made under the UAPA between 2015 and 2019. The same source show that conviction rate has UAPA between 2015 and 2019 is very high, and we can say the conviction rate is roughly around 2%, underlying the weak grounds on which these cases are built. Yet a score of activists, journalists and students languish in jail under the law. Recently the courts, notably the Delhi High Court, have reminded the government of the distinction between protesters, which is legitimate activity in a functioning democracy, and the act of terrorism. In granting bail of 3 students protest under this law, the cruelty which we can see in this act and the Delhi High Court, there is a clashes between Delhi High Court and Supreme Court as well. So we will get to know in the detail what exactly is UAPA is all about is. So the Ministry of Home Affairs declared the Popular Front of India, PFI, is an organization which will be for thinking about the welfare and well-being of the nation, but later on this Popular Front of India is a Muslim organization, and government thinks that this is something as an integrity of sovereignty of our the nation. And as we know, the Ministry of Home Affairs declared the PFI and in front organizations as unlawful association under the Unlawful Activities Prevention Act, UAPA. UAPA passed in 1967. It aims at effective prevention of unlawful activities association in India. Unlawful activities refers to any action taken by individuals or association intended to disrupt the territorial integrity and sovereignty of India. The Act assigns absolute power to the central government, by way of which if the centre deems an activities as unlawful, then it may by way of an official gazette declare it so. It has death penalty and life imprisonment as highest punishment. So as we know that this is something against by a person's like violation of freedom of speech and expression, which is enshrined in Article 19. Under UAPA, both Indian and foreign national can be charged. This is need to be keep mind, because if a foreign land, if the any person who must be Indian and doing some activities, that can be charged. Under UAPA, both Indian and foreign nationals can be charged. It will be applicable to the offenders in the same manners, even if crime is committed on a foreign land or in India. As we know that under the UAPA, the investigating agencies can file a charge sheet in maximum 120 days after the arrest, and the duration can be extended further and intimating the court. This is what the UAPA is in arbitrary manner. The 2004 amendment added Terrorist Act to the list of offences to ban organizations for terrorist activities, under which 34 outfits were banned. Till 2004, unlawful activities referred to actions related to cessions and cessions of territory. In August, Parliament cleared the Unlawful Activities Prevention Amendment Bill 2019 to designate individuals as terrorists. Earlier, UAPA is talking about only for the organizations, but what had happened in 2019 was the pass the bill from the Lok Sabha and Rajya Sabha. The 2019 amendments in UAPA shows that any person can be designated, any individuals can be designated as a terrorist on certain grounds provided in the Act. The Act empowers the Director General of National Investigation Agencies to grant approval of seizures or attachment of property when the case is investigated by the said agencies. This is, against our federal structure. Earlier it was mentioned that without the consent of Director General of the state or Police Commissioner of the state, that you cannot detain to any person, but now the things has been changed. The Act empowers the officers of NIA, the rank of inspector or above, the investigating cases of terrorism in addition to those conducted by DSP or ACP above rank officers in the state. In order to deal with the terrorism related crimes, it deviates from the ordinary legal procedures and creates an exceptional regime where constitutional safeguards of the accused are curtailed. Between 2016 to 2019, the period which UAPA figures have been published by the NCRB, which is National Crime Record Bureau, a total of 4,231 FIR were filed under various sections of UAPA. This frequent application of UAPA indicates that it is often misused and abused like other anti-terror laws in the past in India, such as POTA, which is Prevention of Terrorism Act, passed in 26 March 2002 and repealed in 21st September 2004. And TADA, as we know, Terrorist and Disruptive Activities Prevention Act, between 1985 to 1995 under the background of Punjab insurgency and was applied to whole of India. Associated issues, vague definition of terrorist act in the UAPA. The definition of terrorist act under the UAPA substantially offers from definition promoted by the United Nations. A special rapporteur on the protection of human rights and fundamental freedom while countering terrorism. According to a special rapporteur, to call an offence a terrorist act, three elements must be cumulatively present. This means used must be deadly, the intent behind the act must be cause fear amongst the population or compel a government or international organization to do or refrain from doing something. An aim must be further an ideological goal. UAPA ambiguous definition of terrorist act will include death or injuries to any person, damage or any property, which we can say that any person have a right to live, which is enshrined in our constitution, which envisages in our constitution. If any person which there has a violation of fundamental rights, then that's why UAPA in the ambit of apprehension whether this law is in what context is correct, because it's the curve of terrorist activities. Denial of bail, as we know, the major problems under the UAPA lies in section 43D5, which prevents the release of any accused person on bail if police have filed a charge sheet that are reasonable grounds for believing that accusation against such person is prima facie true. And why it has prima facie true? Because at the end of the investigation, if something is found which is against the person, then we can see. The effect of section 43D5 is that once the police elect to charge an individual under the UAPA, it becomes extremely difficult for bail to be granted. Bail is a safeguard and guarantee of constitution right to liberty, which is in our article, Article 21. So Article 21 of the Constitution, which is definition about right to liberty, and that right to liberty is talking about bail is a safeguard and guarantee to the Constitution, which is enshrined already. So this article is somehow talking against or sometimes supporting. Pendency of trials, given the state of justice delivery system in India, the rate of pendency at the level of trial as an average 95.5%. This means trials are completed every year in less than 5% cases, signifying the reasons for long years of under trial imprisonment. State overreach, because sometimes, as we know, that it also includes any act that is likely to threaten or likely to strike terror in people, giving unbridled power to government to ban any ordinary citizens or activists or terrorists without an actual commission of these acts. Because as we know that India have a federal structure, so somehow if any person can be detained, it's a violation of three fundamental rights, which we will discuss later on. It gives the state authority vague power to detain and arrest individuals who it believes to be an indulge in terrorist activities. Thus, the state gives itself more powers vis-a-vis individual liberty granted in Article 21 of the Constitution. Undermining federalism. Some experts feel that it is against the federal structure since it neglects the authority of state police. Earlier in UAPA, as we know that earlier in UAPA, for example, if any person who is living in Gujarat, then the Gujarat DCP consent is very important before a person is accused to be a crime or person is going to be detained. Now, the NIA person, National Investigation Agency, which was established in 2009, and NIA DCP need to be consent rather than to the state police need to be confirmed. So it is somehow violation of federal structure of our nation. Because as we know that the state's police is a state subject under 7th schedule of Indian Constitution. So as we know, India have a quasi-federal structure. So, but maximum power is tilting towards the nation, tilting towards center. But we have to follow the federal. We will not violate the federal structure of the constitution. What is significant of this judgment? Limiting scope, the court judgment noted that UAPA is meant to deal with terrorist offense. Its application must be limited to acts that can be reasonably fall within a plausible understanding of terrorism. Confirming constitutional freedom earlier this year, Supreme Court. This case is very important. Union of India versus K. Nazib 2021 held that despite restrictions on bail under UAPA, Constitutional Court can still grant bail on the ground for that the fundamental rights of the accused have been violated. This is the case study need to be remembered because in AILET exam and CLAT exam they will ask you committee and case study. So Union of India versus K.A. Najee 2021 held that despite restrictions on the bail under UAPA, Constitutional Court can still grant bail on the grounds that the fundamental rights of the accused have been violated. The court held that regardless of UAPA bail restrictions will melt down where there is no likelihood of trial being completed within the reasonable time. Delhi High Court took this reasonable a step further, holding that it would not be desirable for courts to wait till the accused right to be a speedy trial. While we go to the further, as we know that UAPA Bill Amendment 2019, Unlawful Activity Prevention Act 96 has some highlights. Terrorism under Act, the central government may designate an organizations because as I told you earlier, the Supreme Court verdict that an amendment says that any organizations can be designated as a terrorist organization. Any person can be designated as a terrorist person if the person is involving in some unlawful activities. And third we can say if you are funding to any XYZ organization, or that organization is working for the sovereignty and integrity of the nation, then you can be detained in UAPA Act. So under the Act, the central government may designate any organization as a terrorist organization, commits or participants act as a terrorism, prepare for the terrorism, promotes terrorism, and involved in terrorism. The bill additionally empowers the government to designate individuals as terrorists on the same ground. Seizure property under the Act, the investigating officer must obtain prior approval of DGP or seize property that may be connected with terrorism. If the investigation is conducted by an officer of NIA, National Investigation Agencies, the approval of Director General NIA is mandatory. Under the Act, investigation of cases may be conducted by officers in the rank of DSP or ACP or above. Officer of NIA is the rank of inspector above, can also investigate cases. What is the recent issue if you talk about? So as you know, Popular Front of India, PFI, created in 2007 through the merger of three Muslim organizations in southern India, namely National Democratic Front in Kerala, that is NDF, Karnataka Forum for Dignity, and Manitha Nithi Persai in Tamil Nadu. So that all three organizations merged and PFI was created in 2007, Popular Front of India. Formation of PFI was formally announced by a rally in Bengaluru during what it called Empower India conference in 16 February 2007. How was unlawful association defined? And that PFI is completely banned by the UAPA Act. Section 2(1) clause of the UAPA defines an unlawful association as an association which has for its object any unlawful activities or offence defined under Section 153A or 153B of the Indian Penal Code. That is, promoting enmity between different groups and making imputations, assertions that is prejudicial to national integration. An unlawful association is also one that encourages or aids persons to undertake any unlawful activities or which the members undertake such activity. What process to declare an association is unlawful? So under Section 4 of the UAPA, the government is mandated to send the notification to the Unlawful Activities Prevention Tribunal within 30 days of issuing the gazette notification to have the ban ratified. And the concerned ministry will have to make a reference to the tribunal. Tribunal and court is working a similar structure. So ministry also reference to the tribunal along the details of cases of NIA, and NIA is a sole body which would be responsible to detain to some one person, and ED which comes under Ministry of Revenue. EB comes under Ministry of Revenue. As we can see that many of the IRS officers would be in the Enforcement Directorate. And a state police force that register against PFI and it cadres across the country. The tribunal which is required to be headed by retired or sitting judge of High Court will show cause notice to the PFI asking it to reply in writing about what it should be banned. After argument from both sides, the tribunal can hold an inquiry to decide within 6 months. So basically the unlawful we can say that Unlawful Activity Prevention Act, that we can say that somehow is supporting for the curbing of, like we can say, a terrorism, but in another case we can say that it is somehow violation of someone's fundamental rights. Freedom of speech and expression is violated, freedom of right to liberties is, we can say, violated. So the ban becomes applicable for a period of 5 years once the tribunal approves it. So what are the consequences of being declared unlawful? After declaring some organization is unlawful, that as we can say that they people start making some other organizations. So declaring an organization unlawful, as has happened in the case of PFI now, has serious consequences in law, which includes the criminalization of its membership and the forfeiture of the properties of the organization. Under Section 7 of the UAPA, the government has power to prohibit the use of funds of an unlawful association, and under Section 8, all places that are used by the unlawful association can be notified and seized. Bail provision under UAPA. What are the bail-related provision and issue in UAPA? The major problems with the UAPA lies in Section 43D Clause 5, which prevents the release of any accused person on bail if police have filed the charge sheet that are reasonable grounds for believing that accusation against personnel is prima facie, which we have already discussed. In case of Zahoor Ahmad Shah Watali, Supreme Court in 2019, why Supreme Court verdict is important? Because if the Supreme Court verdict, you have to keep in mind that if the time the Supreme Court verdict is issued, the another time once the case study was passed, another time the same reference will be taken out for making, and we can say, hearing some decision and publishing some decision. So in the case of Zahoor Ahmad Shah Watali in Supreme Court for 19 confirmed that courts must accept the state case without examining its merits. However, court have since read the provision differently, emphasizing the right to a speedy trial and raising the bar for the state to book an individual under UAPA. So under UAPA, both Indian and foreigners nation can be charged. If a person who is doing any activity which is against the sovereignty and integrity of the nation, that person can be detained. It will be applicable to the offenders in the same manner even if crime is committed on a foreign land outside India. And under the UAPA, investigating agency can file a charge sheet in maximum 180 days after the arrest, and the duration can be extended further after intimating the court. And what exactly the amendments of 2019? As per amendments of 2019, the Act empowers the Director General of National Investigation Agencies to grant approval of seizure or attachment of property when the case is investigated by the said agencies. The Act empowers the officer of NIA of the rank of inspector or above to investigate case of terrorism in addition to those conducted by DSP or ACP rank, which we had already discussed. So in short, if you talk about UAPA, which we have already discussed, Unlawful Activity Prevention Act 1967 is parliamentary law that gives power to central government. If you go to the history of why UAPA was enacted, so we can say that the time of India-China war, at the time of India-China war, that we can say the same time that Madras is talking about like to session, like we can say the Madras is demanding about separate state. So the same time that, as we know, the Article 352 of the Indian Constitution, which talk about national emergency, but government does not have anything which in the mind. So that's why government enforced the UAPA that time, so Unlawful Activity Prevention Act, and that gives power to central government to deal with activities directed against the integrity and sovereignty of India. And as we know, UAPA is both Indian and as well as foreigners. Amendments: NIA officers of the rank of inspector or above can investigate a case of addition DSP or ACP rank officer. The law empowers the government to designate individuals as terrorists. Earlier it was, before amendments of 2019, only the organizations, such kind of like PFI and all, that can be designated as a terrorist organization. Concern: it gives absolute and sweeping powers to the central government to arrest individual indulging in an activity is considered as unlawful. The court are bound to give stringent punishment under the UAPA even if offense is not serious. So we can say anti-terrorism law, there are many laws that we can say TADA, POTA and UAPA. So if you talk about TADA Act 1987 was the main law used in case of terrorism and organized crime, problem rampant, misused. And another thing that we can say, POTA in the wake of 1999, and the third we can say in UAPA 2014, in 2004 was enacted. Criticism in 1967, India introduced unlawful activities. This all things we are discussed already. And now here it is the questions of the day. Okay, sorry for the delay. Am I audible, guys? Please let me confirm. Actually, due to some technical glitch, so that's why that we could not further proceed, because the topic has been done. Only the few questions has been left. So I hope that in the next session that we will discuss about to try to focus on UAP Act, because only now the questions is only left as we can see. So the last pages have been showing in the previous thing, so that's some kind of technical glitch. So don't worry about it. So the next session that you guys are ready, because I will ask you some kind of question that is based on UAPA. So I hope you enjoy the session a lot. In the next time that we will discuss about any topic if you guys want, like such kind of topic you want to discuss, so please let me know in the comment sections. So if you have any issue, please let us know, that we guys is always eager to help you out. If you are new in this channel, please subscribe and share to your friends as well. And if you have any query, please let us know. Thank you so much for joining the session. And if you are new, please subscribe the channel Pratham Test Prep. Thank you so much. Bye bye and take care. We will meet you tomorrow at the same time, 11:30. Bye bye and take care.